Thank you, Congressman. I just wanted to echo the concern raised by your question. There are approximately 5,000 different broker-dealers, many of whom are small business operators, which is why in my oral statement I indicated that while as a task force member I agreed with the notion of increasing the level of protection to the 1.3 million, one piece that we as a task force just did not really analyze is the cost. What will these costs ultimately require for all the broker-dealers, from the smallest firms up to the largest? So I just think that's a relevant question and part of the data analysis that should occur.
Mr. Caruso.
Thank you, Congressman. I mean, obviously, we don't have access to the member assessments from SIPC as far as who's paid what over the past number of years. But looking back just a few years ago, realize Citigroup Global Markets, Smith Barney, Merrill Lynch, Morgan Stanley, those firms paid a total of $150 apiece. So does the system have to be changed? Certainly. You can't have a firm of that size with thousands of brokers paying $150. To come down here today, the shuttle cost me $800. Now, at $150 a year, I would have paid my SIPC dues for almost 6 years. That is insanity. And that is what's at the core of the problem today, and why I would suggest a SIPC fund with just one more catastrophe will not be viable any longer on its own or with the Treasury backstop.
Mr. Bohr, thank you.
The question of assessments really depends on what the focus of the fund is to do. If it's going to be limited to where it is now, at least under the current interpretation, that's going to be one assessment. If you're going to expand it to cover potential losses on statements that may be inflated, especially 20 years worth of Bernie Madoff, that's going to be a completely different assessment. I think the committee, the task force, when looking at this, made recommendations not knowing what those costs would be. So we took what was the current law, the Dodd-Frank 0.02 quarter of 1% on revenues, and said that's what the law is now. And what we only did was say, look, it's ridiculous to have 150, at least have some minimum. But I think it's incumbent upon Congress to decide where the parameters are, and I think a lot's going to depend on this SIPC, SEC versus SIPC lawsuit. Because quite honestly, if SIPC is required to pay the Stanford or the accounts stated on account statements, then I would submit to you I've got about $4 or $5 billion worth of Reg D 506s sold through broker-dealers on oil and gas deals and medical facilities that also would be required to pay. What my concern is on the bills is not what you're trying to accomplish, is that they only cover certain Americans in certain situations. You've got to everybody's entitled to equal protection of the law. If you're going to cover Stanford, which in essence is going to cover an overseas bank, basically turning SIPC into FDIC insurance for an overseas bank, what about one of my cases? Mallory is a now defunct broker-dealer. I put them all in jail. There's no assets, but I've got probably $600 million worth of account statements and folks who invested in U.S. projects that were fraudulent. There is no SIPC coverage for that. I can't give them their money back. Let's cover it for all Americans. But at that point, you have to look at what that universe is. You cannot parcel the universe and say just Stanford or just Madoff, cover it everybody, or decide not to cover anybody, or try and find some level of protection that everybody can participate in.
Thank you, Mr. Chairman.
Sure. So, just on that last line, I'm sorry, I wasn't familiar with that case. So that was not a securities case. That was in
most of
that last.
Sorry, Mr. Chairman.
They were.
Yes.
They
Mallory was a broker dealer out of California.
Yeah.
It was FINRA registered. However, they specialized in the private placements under Regulation 506, which is exempt from state securities jurisdiction, except for enforcement. There's no gatekeeper function. And what we discovered was that out of Southern California, they were running a operation where they would do multiple 506s. 72 to 75% of all the money went to the company, salaries, bonuses, salesmen. There was never any money for projects. They'd open up a little project, and there was no chance it would ever succeed because there was no money to fund it. And this was a primary fraud. We see the same thing with captive broker-dealers in the oil and gas industry, where an oil and gas developer will set up a broker-dealer and sell only oil and gas placements. DBSI out of Idaho was a real estate pool.
How does that come? And that does not come under, would not come under the SIPC then?
No, because it's all fraudulent statements with false profits. It's identical to the Stanford situation.
Yeah.
But if the case turns out that it's covered, then I think all those have to be covered as well.
Yeah. And I have a couple of particular questions, but I mean, I guess there goes. Well, Ms. Bowen actually raised some of that point before as to that there are other classes, there are other activities of fraud that are out there, and we're trying to address where this fraud should be covered. Right? And I appreciate that. Part of the problem in this particular area is where you clearly in Madoff, which is the more infamous one, where you're looking in that situation. There was an expectation. There A was covered, right? And B, there was an expectation of coverage. Now we get into the two issues that we have in that particular case. Obviously, the one that the gentleman from Colorado picks up on the most, which is the feeder fund situation, and what was the expectation in that situation as far as the unlearned, the average investor in that situation, and the other is the situation is about the various pools of funds that are available for this. For recovery, and so, and to that, to those separate points, Mr. Berg, you raised the point, I guess, in your opening comment, just a sideline on this, is how mutual funds are treated under this. The fact that they have the logo there, so to speak, although I guess most people really don't see that since you're dealing with a lot of this over online nowadays. And your position was, and I'll look at the rest of the panel, as to what the solution is dealing with mutual funds. The exemption is appropriate, or is the exemption or the simply removing of that logo and say since they're not going to be?
Mr. Chairman, I disagree with the rest of the task members on this point. I thought mutual funds, because they do, one, use the logo, and two, because money's going back and forth in brokerage accounts, and there's all these mutual funds that are being held in street name for that matter, all those shares that back up the mutual funds. I just thought they should not be an exemption. I don't know what that kind of money would bring in, but that's a huge industry.
Does anybody else want to, just since we know where you are on that, just so I understand where the rest of the panel is?
The only thing I would offer, Mr. Chairman, is when we explored that issue as part of the task force, one of the things we looked at were how often do mutual funds fail? Yes, they all use the SIPC logo, but they don't pay anything for it. And the counter argument from the Investment Company Institute, the trade association for mutual funds, was none of our members ever fail. As Commissioner Borg indicated, mutual funds are a huge business in today's day and age, and they are part of the securities industry. But, historically, they have been carved out, revenues from mutual funds. And I think given the current financial position in the environment, it's something that needs to be revisited.
Right. Anybody else?
The only thing I would add, Mr. Chairman, is that many mutual fund complexes have broker-dealers as part of the complex. That's how they sell the mutual funds. So there would be SIPC coverage and assessments at that level.
The magnitude of those funds would, the magnitude, I guess, is still de minimis based upon the current configuration. Mr. Stein?
I would agree exactly with what Mr. Hammerman just said on that.
Yeah. And as long as I'm down here, and since I can give myself as much time as I want, but I'm mindful of your time. So SIPC says what with regard to the payment method, cash in, cash out, right? When you're dealing in net equity calculation. Do you just want to spend a moment on the appropriateness of that? And then to bifurcate that issue, and the rest of the panel, I'll throw it out to you as well, to bifurcate that issue to the fact that you can bifurcate that as far as to whether you have one pool or two, right? The advances or the other assets clawed back, and show your answer. Your comment would be on, in general, A, and B, should there be a distinction when you're dealing with both pools?
Sure.
Okay.
Sure. Let me get to that.
Okay.
All right. So when Congress passed SIPA law in 1970, at the same time that it was moving away from the use of physical securities that you referred to earlier today, it was doing so at the same time it was making an agreement with the American public of offering a degree of assurance that what was going to be replacing that physical security had to be meaningful. It was intended to be modeled on the kinds of assurances that were provided by the Federal Deposit Insurance Corporation, FDIC. In fact, the original legislation was essentially a cut and paste from the original FDIC legislation. But the upshot, it was trying to establish for the small investor, to protect the smaller investor and create a state of certainty so that an investor knew that when we were dealing with something that was on an account statement, it was a true and honest and legitimate reflection of what they owned. Congress made this recommendation amidst a backdrop of failed brokers, of Ponzi schemes, of thefts. The circumstances all existed that we're talking about today in various forms. And Congress still said, we are creating a SIPC fund. This fund is going to protect the net equity based on understood to mean final account statement so that an investor knew when they looked at their statement that they owed something. And it was necessary because, after all, we were looking at protecting the smaller investor, and Richard Nixon's statement when he signed that legislation is a profoundly powerful one. And what it does tell us very clearly is that investors that are in their later years, that are now living on their retirement funds, cannot afford to think that their protections are being reduced by the amount of money that they pull out of those funds. That the profits that their hard-earned savings have made on those funds in those accounts, whether it's at a bank or a financial institution, have to be protected. And that we're still somewhere down the road that no trustee can come in 20 years hence and say, no, you've got to give that money back. That's precisely what's going on now. So the SIPC fund itself has to be based upon the reasonable expectations of final account statements. And frankly, if the statements are outrageous or wrong, then we really have to get to whether or not a person receiving those statements was willfully turning a blind eye. And the courts have the ability to say, no, you're getting 40% return, maybe you don't get that protection. But when we come to the issue of the recovery of customer property, and I think that's where so much of the time has been spent, maybe there's a different standard. And the trustee has had the flexibility to apply a different standard and a reasonable standard. And that standard could incorporate the time value of money. It could find some way to equitably determine what the fair distribution would be of the recoveries of those monies. But it should not eliminate the use of final account statement and reasonable expectations on the core of this protection, which is the SIPC fund. So customer property has an opportunity to have all kinds of equitable, rateable methodologies applied to it to come up with a good solution based upon what the trustee sees at that particular time. The fund, however, that belongs to SIPC, the SIPC fund, is inviolate. It cannot be modified or changed. It is what the customer has to be relying upon for their protection.
Rest of the panel?
The only thing I would add, Chairman Garrett, is the one thing that's been clear from today's hearing is how do you stop this problem? You don't allow people to prepare their own account statements. If Madoff had not prepared his own account statements on one side of his floor, none of this would have happened. So a very simple solution, if we want to keep this from happening again, is I cannot prepare my own statements. That solves the problem.
Mr.
In
Bork.
my office, investment advisors are looked at once every 3 years on a rotating cycle. We use a risk assessment. If they have custody and control, they go way to the top of the list, and they're looked at a lot sooner and a lot quicker. If they are strictly financial advisors that just give advice and they have no custody, no control, no physical assets, no physical custody of the property, then they go to the bottom of the list because there's a clearing firm or someone else out there. The comment was made, and we try and encourage at least the investment advisors under our jurisdiction Madoff would have been under the SEC jurisdiction, is that get a clearing firm. Again, I agree. A lot of these problems with these Ponzi schemes, if they're going through either a brokerage or usually an IA, can be eliminated by actually having a dual or triple control, because now you have three entities that have got to conspire to make it all work.
Unless, of course, you control all three entities, and as in the Madoff situation where...
In that case, I would consider that as a unitary control, because Mr. Madoff actually had control over both ends of his business. There has to be a Chinese wall between the two. Even where there are clearing firms that self-clear, we look at the controls between the two. Usually it's an outside auditor or an outside advisor or some other third party that has to certify that they've looked at those systems and those systems are intact.
Have you ever had a case where you have a separated a situation like that where there is collusion, that it doesn't solve the problem, as Mr. Caruso suggests?
I have not seen, yes, one time that I can think of. In fact, it gets tied up with that Mallory case because there was a separate organization called Capital Guardian which handled the trust accounts.
Okay.
In other words, if you had an IRA
Yeah.
and there was collusion between the two. There was joint ownership,
Okay.
but it was so cleverly disguised it took us a little while to find it.
Find that, yeah.
But it didn't last 20 years.
Yeah, yeah. Well, that's because you had good folks over there digging into it on a regular basis, I base it. So
Thank
they
you, Mr.
undercover-
Chairman. I appreciate
yeah,
that.
Sure. Well, if Mr. Hurt does not have any other questions, at this time I will dismiss the panel and thank you all very much for your testimony today. As always, there may be and there will be other questions that we would probably, so the record's always open for another 30 days to submit questions to you, so I appreciate the opportunity to do that. And without objection, I'll put into the record from a statement for the record for today from the Financial Services Institute and also from BDA Bond Dealers of America. Without objection, that's so ordered. And again, I very much appreciate this entire panel for your information and discussion today. Thank you.